limited to personal injury and insurance law.
Welcome to Lawline with your host, Alan Storman. Mr. Storman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Storman.
Welcome to Lawline. The violent and brutal attack of Haitian immigrant Abner Lorima and the subsequent trial of 5 police officers resulting in 1 guilty plea, 1 conviction, and 3 acquittals leave many questions unanswered. Today we'll get some insight into this highly explosive case when we talk to Joe Tacopina, a criminal defense attorney who represented one of the acquitted officers, and Peter Vigeland, a former assistant United States attorney who now represents white-collar crime defendants. Hello, Joe. Hello, Peter.
Hello.
Joe, why don't you tell us a little about the case and your client?
Well, you know, obviously it was a horrific case, horrific allegations, horrific actions by one of the police officers that really swept everyone under.
Well, since we're shown all over the world now on the internet, why don't you just briefly give us a concise version?
Well, there was a melee outside of a nightclub in a Haitian community in Brooklyn, and a man got involved with one of the police officers, and that man was subsequently back at the precinct after being arrested.
It's Abner Lorima.
Abner Lorima was sodomized by Justin Volpe in a precinct bathroom. You know, an unthinkable, unspeakable act that shocked a lot, made a lot of people really take notice.
Was Abner Lorima restrained at this point when he was sodomized, or?
No, Mr. Lorima says, and jury, Mr. Volpe pled guilty to holding him down and having him rear handcuffed while he sodomized him with a stick.
Okay. And what about your client? What was he involved in?
Well, you know, my client, as I said in my summation to that jury, the federal jury, wouldn't have been there that night, that day, in federal court as a defendant, but for the actions of Justin Volpe, someone who I described as a monster to that jury, because, you know, the acts were so horrific, so unspeakable, so heinous, that it really caused everyone who was around Mr. Lorima that night, who laid a hand on Mr. Lorima that night in the arrest process or otherwise, to wind up being a criminal defendant in a federal courtroom. And it was really based on the actions of one police officer.
Now, Peter, if I recall, right after the conviction, and I believe Officer Schwartz was convicted, is that correct?
That's right.
Right after the conviction, I saw the attorney, Marvin Kronberg, on TV, who said that Justin Volpe had told the United States Attorney's Office that he wasn't alone in the bathroom, but it wasn't Schwartz who was convicted of being there, but it was someone else. What's your take on that?
Well, as a former federal prosecutor, assuming I'm the prosecutor in that case, I think it would be incumbent upon me to see if Mr. Volpe would speak to me as a government representative, and I would interview him and assess his story, and to see whether that caused me to rethink the government's theory of the case, which I understand was Mr. Schwartz was the one holding him down, and not Mr. Weiss.
Weiss.
I mean, not Mr. Weiss.
Right. Now, that's what Marvin Kronberg said, that it was your client actually holding him down. Is that correct?
No, it's actually not what he said. Volpe said he acted alone.
Okay.
No one held him down. What he said was, contrary to what Abner Lorima testified to, was that no one else held Mr. Lorima down, but that at some point during the attack, Weiss walked in. And
your client?
My client. And there was this sort of clairvoyant meeting of the minds between Weiss and Volpe, and Weiss sort of stood guard for Volpe, which obviously was laughable, ludicrous, and far from the truth. The government didn't believe it for a second. Thomas Weiss, before any Justin Volpe revelations, before anybody else did anything, days after this incident, Alan, you must remember that Thomas Weiss went into the Brooklyn DA's office and said, I walked into that bathroom and I saw Justin Volpe and Abner Lorima, and I saw a stick, and I saw feces, and I saw all this stuff, and I don't know what to tell you, but here's what I saw. I just didn't see Charles Schwartz in there. Obviously, that did two things. One, the government chose not to believe Weiss because it didn't include Schwartz being in the bathroom. what it also did was, in effect, put an end to the defense of Justin Volpe. It really put a nail in the coffin of Justin Volpe, and certainly Volpe saw this to be a ripe opportunity to enact revenge. The only problem with that is Weiss was acquitted. He will not be retried in the factual part of the Lorima case, in the assault part of the Lorima case. And the other problem is the government doesn't believe that Weiss was the second police officer.
Peter, what I don't understand, and it's a little confusing, and if it's confusing for me, it's got to be confusing for a lot of people. Justin Volpe, through his attorney, after he was convicted, stated, after he pled guilty, and after Schwartz was convicted, that it wasn't Schwartz in the bathroom. It wasn't that man, it was someone else. Well, question, was Mr. Schwartz entitled to know this testimony during the trial, that at least Officer Volpe had told the U.S. attorney that it wasn't him, but it was someone else?
I think the government should have disclosed that information. There are two questions that arises. One, did the attorney for Mr. Schwartz know this during the trial? And that's really something that I imagine Mr. Tacopina can address. And two, even if it were known, there's a difficult evidentiary issue as to whether this statement could be brought before the jury, and I don't know how technical you want to get here, but there are a lot of evidentiary bars. I think in all likelihood Judge Nickerson would not have allowed that type of statement in to exonerate Officer Schwartz.
But Joe, couldn't the attorney for Officer Schwartz call Volpe to the stand even during the trial?
Well, as a matter of fact, he made a tactical decision not to. Let me answer your question. Deputy further. He knew, the attorney for Chuck Schwartz knew what Volpe was going to say. But he made a decision not to call Volpe to the stand, and it was a decision, quite frankly, that I don't see how anyone who really knows the case could quarrel with at the time. I mean, you have a situation where, Justin Volpe was now admitting to one of the most heinous acts imaginable. There was such graphic testimony during the trial about his conduct right after the act, about how he was bragging and how he, did all these disgusting, despicable things that he now feels remorseful for. So he says, and Schwartz's attorney made the tactical decision not to put his client in bed with Justin Volpe. We didn't need his testimony, so he felt, because at the time the Schwartz defense felt pretty confident that there was reasonable doubts. I certainly am not in a position to quarrel with that decision.
Joe, can you share with us one thing, again, something else I didn't understand? The most that Justin Volpe could get, he wasn't going to be killed, he wasn't going to be executed, he wasn't facing that, even if he was convicted, but he was facing, if convicted, life without parole.
Right.
And now he pled guilty during the trial to the very charge which he was charged with.
Right.
And I understand he's now facing life without parole anyway. And everybody indicates that's what Judge Nickerson most likely will give him.
Yeah.
Why would he plead guilty? And
that's something that Justin Volpe and Marvin Kornberg are going to have to look themselves in the mirror and be able to answer, because I have no clue. If Mr. Kornberg really, felt that his client were going to be convicted, the time to really evaluate the evidence and sit down with your client and make those decisions or before the trial, where you could get something called acceptance of responsibility reductions on your guidelines. But to do it after the government's case is in its entirety, there is a slim and remote chance that you could get acceptance of responsibility. But at this point, it was more of a gimme, waving the white flag, basically saying, I quit, because there was no chance at that point, apparently, that Volpe was going to be acquitted, according to the analysis of the trial. I mean, the testimony was devastating against him.
I'd like to make two comments here. I agree with what Joe's saying, that there is a slim possibility in terms of why Mr. Volpe may have chosen to do so. To the extent he's thinking rationally at that point, there is a slim possibility that he could get a discount, if you will, for acceptance of responsibility under what I call the federal sentencing guidelines. One thing that Joe said I would somewhat quarrel with, you don't really know whether Marvin Kornberg knew all the facts at the time this trial commenced. When you represent criminal defendants, sometimes they're less forthright with you at a certain point in time than they are after all the evidence comes in. So I don't know whether it's fair to fault Mr. Kornberg for not urging a guilty plea.
I do remember Mr. Kornberg on the evening news, and I'll never forget this, before the trial started, where he indicated that you will learn during the trial about a homosexual act that Abner Lorima conducted which was part of this of the evidentiary, and you'll learn that that's what contributed to his illness.
Well,
that never came out.
Well, of course,
You were there.
It never came out. It was fictional. It was fantasy. It was some concocted defense that fell flat on its face. And
Did he open to the jury with that?
He alluded to the fact that you'll find that this was the result of a consensual act. I mean, you know, the jury picked it up loud and clear, and the papers reported that basically the defense was alleging, Mr. Kornberg was alleging that Abner Lorima had suffered these injuries through some sort of rough gay sex. You know, certainly it was something that I distanced myself from in the opening statement. I stood up there and said, ladies and gentlemen, whatever he says has nothing to do with my client. You know, and I actually put a chart in showing the indictment how it was broken down that my client was not charged with the bathroom attack, and we don't subscribe to the Volpe defense. You know, that's as far as we went, and you know, I had no say in that, obviously, Alan. As far as what Mr. Kornberg knew before trial or didn't know, you know, I think I understand and know some of the things he knew because I had discussions. I'm not going to get into those, you know, right now, but suffice it to say that it was a real high-profile type of an opening statement to make, and it certainly got Mr. Kornberg that red ink, end of the world publicity that he so likes. But it was something that fell flat in his face, and certainly, I think, sort of spilled over to the Schwartz defense.
Peter, now I understand that Mr. Schwartz has a new counsel.
Ron
You
Pichetti. Right.
no longer has the counsel who tried the case. Can Mr. Schwartz appeal it and saying, listen, my counsel was ineffective, did a terrible job for me, should have done this, should have maybe called Justin Volpe to the stand, who would have said I wasn't there?
Well, there are two arguments that can be made on appeal. One is that this statement by Mr. Volpe that Mr. Schwartz was not in the bathroom is newly discovered evidence. From what counsel here says, that seems to be a difficult road to hoe if counsel knew about it at the time and made a tactical decision. Then the only argument on appeal is an ineffective assistance of counsel argument, which is often made and it rarely succeeds. If you make a tactical decision on behalf of your client, which ultimately turns out to be a wrong tack to have taken, that is not the basis for a reversal. You have to show that there is really a conduct far below the norm, and that may be very difficult to establish.
At least one of the jurors may have, at this point, believed Justin Volpe if he would have taken the stand and been subject to cross-examination and subject to direct that Mr. Schwartz wasn't in the bathroom.
Well, a couple points there is, one, you do not know whether Mr. Volpe would have waived his Fifth Amendment privilege and permitted himself to testify.
This is after I'm talking about he
pled.
Oh, you could still?
Well, he could still because it's not guaranteed he's going to be in jail for life, and there could be other charges that could be brought against him. Two, a juror saying that they would believe Justin Volpe is different than what a juror would react to in terms of his testimony after full cross-examination by the prosecutor, which I imagine would be pretty vigorous and might well be very effective. So a juror just saying that I don't think provides much fuel for appeal.
Joe, what was it like dealing with the other attorneys in this very highly publicized case, worldwide publicity, and here you're only interested in your client?
I'll tell you, Alan, it was, you know, by far it was the most difficult task in this whole case. I mean, for the most part, the defense attorneys in that case got along well, with the exception of Mr. Kornberg. I'll be quite frank with you. You know, there's a bitter animosity between Schwartz's attorney, Steve Worth, and Kornberg. That was aired before the trial, during the trial. Certainly, Mr. Kornberg and I are not two people who see eye to eye on almost anything. You know, there was really almost no communication with him at all at the trial, and nor did I need there to be any communication. I certainly didn't subscribe to his defense, nor was I concerned about what he was doing. Obviously, I was concerned about it from the jury standpoint. Would they see us all as, you know, 5 rogue cops who engaged in this horrific act of brutality, or would they be able to do what they swore they would do in the jury selection, which would be to view each defendant separately? That's the toughest task anytime you have multiple defendants in one case, to make sure, especially if you're the defendant that does not have the amount of evidence that the lead defendant may have against him. You want to make sure the jury separates your client and views the evidence separately.
How long did the trial go on for?
I think 4 or 5 years.
4 or 5?
Well, is what it felt like, Alan. I'm joking. I mean, I think actually, I think about 6 weeks between jury selection and actual testimony.
We'll continue with the trial of, at least this year, the Abner Lorima criminal trial right after this break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
Where's Michael?
National Guard duty.
Ah, bet he's just sandbagging.
I don't think so.
Sure he is. He left us with all the big fires to put out.
Over 52% of our military is made up of the National Guard and Reserve. They serve in times of war and in times of disaster. And the jobs they perform are hard enough, without you making it harder.
Well, let's hope he's ready for some late nights when he gets back.
Please support your employees in the National Guard and Reserve.
You are 100% unadulterated energy. You have no choice but movement. You aren't acted on. You are action. You have the power to make the world a better place. You already know how to do it. Volunteer now for the American Red Cross. Call your local chapter for details.
I didn't mean anything. It's just you're getting so angry.
That's enough! Enough! I'm gonna give you something to scream about! Get over here! Get up!
I can't.
I'm talking to you! Get up!
I can't.
Stop crying! You're asking for it again!
For information about how you can help stop domestic violence, call us.
Hello, I'm Alan Schnorman. You're watching Lawline. We're talking about the aftermath of the verdict in the Abner Lorima trial. Our guests are Joe Tacopina and Peter Vigeland, former U.S. Attorney, Assistant U.S. Attorney. Joe, I'd like you to take me into that jury room, into the did you speak with the jurors after the trial?
No, the federal rules don't really look kindly on that, so we didn't get a chance to speak to the jurors. They were also sequestered and anonymous.
Interesting. So you don't even know who the jurors were?
We don't know who they were.
And what about during the trial? If I go into the courtroom, was there tension every day?
Yeah, it was amazing. It really was amazing between the hordes of press, the political ramifications in the case, obviously the life ramifications for the defendants in the case, the battling amongst attorneys and defendants, the racial undertones in the case. There were certainly more than the normal trial's share of tension in that courtroom every single day for 3 months.
Now, you represented Police Officer Weiss. Is he back to work now?
He's been paid. He's still being paid as a police officer. He's still on a modified assignment. So, in essence, he's really getting paid to do nothing.
And is he facing any other charges as a result of the Abner Lorima assault?
Well, not as a result of the assault. I mean, he's been acquitted of laying the glove on Abner Lorima. He'll never be retried for assaulting Abner Lorima, but what he does face, along with Officer Bruder and Schwartz, is that the government alleges that the three of them got together and conspired to take Charles Schwartz out of the bathroom. In other words, to say that Charles Schwartz was not in the bathroom.
They're saying he lied to government officials.
Right. He, Bruder, lied to government officials by saying, here's what happened, we saw X, Y, and Z, and Schwartz wasn't in the bathroom. The government believes that was some sort of a lie intended on obstructing justice, and we now face another count.
And now, go back to your prosecutor's hat. Now, I know you left it a few years ago.
I'll find it.
But if you were sitting there, and of course it's difficult for you to do it, would you actually pursue these charges against these officers for obstructions of justice?
I would feel duty-bound. I have one question. I think there's an obstruction count against 3 officers. It's Schwartz, Bruder, and your client, right? Okay. I think, as a prosecutor, I'd feel duty-bound to do so. The case is an extremely serious case. It implicates federal interests. I mean, it's very important for the citizenry to believe that police officers will be held accountable both for brutalizing someone in their custody and for telling the truth about other the horrific acts of others should they be questioned. So if you feel that the facts warrant a conclusion that someone lied about something that important, I don't see how you can avoid prosecuting that
but
person.
on the other hand, Peter, here we have Abner Lorima, a man who no one from my camp anyway would ever ask anybody to, forget about the tragedy he suffered. But here you have a man, Mr. Lorima, who lied repeatedly to state prosecutors, state police officers, federal prosecutors, FBI agents, and got caught in all those lies, at least a half dozen lies, serious lies about who did what, about who witnessed what. He even put a false witness at the scene where they accused my client of assaulting Abner Lorima in the car. I mean, he actually put false witnesses in front of the club, people who weren't there. He made them go and give statements to the FBI. I mean, you're talking about someone's liberty. As horrible as what happened to Abner Lorima is, you're talking about the liberty of an innocent man. My client, yet Abner Lorima got a free pass. His family got a free pass. But everyone else got a free pass.
But why is that relevant? In other words, even assuming Abner Lorima did all these wrong things, if your client, in the government's view, lied about whether or not Officer Schwartz was in the bathroom, don't you think they're duty-bound to prosecute him? Isn't that really an easy call for the prosecutor?
Then they're just as duty-bound to go and prosecute Jonas Lorima, Abner Lorima, Jay Nichols, and all the others who conspired to lie about that.
How serious would this charge of obstruction of justice be to Officer Wise and the other officers?
As a legal matter, Joe can speak to that, but I think it's a 5-year count. So
That's
the max.
Pretty serious.
But
very serious.
But it's capped at 5 years compared to what these other officers are. So he's done a wonderful job for his client. The only count that's remaining is a count that gives a maximum sentence of 5 years.
Now, will Justin Volpe be brought to testify if that comes to trial?
That's certainly not my call. I have no use for him whatsoever. Mr. Schwartz's new lawyer may choose to call him at this case, although, again, the issue in this case legally really has nothing to do with the Schwartz conviction. The Schwartz conviction, the appellate route, will take its course. And if affidavits from Justin Volpe will aid Mr. Schwartz and my client, affidavits from him will aid Mr. Schwartz, they'll be procured, I'm sure, by his lawyer. This case is really about whether these three got together to conspire to lie about Chuck Schwartz. Now, certainly the underlying issue there is, was he in the bathroom? So Volpe may be a witness at this case, may not be, who knows. This case is taking more unexpected turns, Alan.
Well, of course, you could understand if no one wants, especially an innocent party, to be convicted, especially the innocent party. I mean, that's the biggest fear any citizen has, is that you're going to be convicted of a crime that you did not commit, spend years in jail or your life in jail.
Mm-hmm. Yeah.
And be totally innocent. And of course, your client says he wasn't there.
Which is why we have another trial. I mean, the odd part of this whole thing is... My client says
Schwartz was not in the bathroom when I was there.
Long before Justin Volpe came to this version of events, he started out with the gay sex thing, then he had a memory blackout, he claimed he didn't remember anything, and now we're on his third version. Long before that came into play, days after this incident, said, I walked into the bathroom. No one in the world put him there, but he did. He saw Abner Lorima and Justin Volpe, but not Chuck Schwartz.
If somebody walks into a bathroom of such a nature, I guess that's a crime. Are you under any obligation, Peter, to stop it? Or to say to the desk sergeant, hey, look what's going on here?
I think that's a closer question as to whether there's an affirmative duty placed on police officers as to someone in their custody to stop it. I think there's an argument.
Separate apart from this case.
But I think the issue here is kind of much more cut and dry. The question is when a police officer is interviewed, the truth must be told, and I think the government has a very simple prosecution here. Whether it's successful or not is another question.
I appreciate that, but from a prosecutor, is there any charge? Does an officer have an obligation to stop a crime that they see?
Well, if you remember back, there was the graffiti artist that was killed in the custody of the police officers, the transit police officers in Union Square, maybe 10, 15 years ago. I think his last name was Stewart, or. Right. And the theory of the prosecution there was a kind of duty of care, much like a mother or father would have for a child in their custody. They argued that the police officers, having arrested this person, had a duty of care because the Manhattan DA's office couldn't determine which of the officers inflicted the fatal blows. That prosecution, I think, ultimately led to an acquittal, but they must have passed muster with the judge and gone to the jury. Aside from that, I'm not aware of that theory being the predicate for a prosecution.
Joe, you were there. If you were representing Schwartz, would you have done
I wasn't there. I was in the courtroom. I wasn't there. But
if you were representing Schwartz for the trial, would you have done it any differently than his attorney?
You know what? Yeah. How easy it would be
Hey,
the
you
second
can talk.
guess. But I honestly, I can't say that I would have, Alan. I really, then I would be the one facing the brunt of the criticism like Steve Worth was. I can't say I would have done it differently. I think he did a phenomenal job, and I think he did a good job raising doubts. I certainly sat there and thought there were enough of them. But again, there are certain things that are hard to overcome, and it's hard to overcome when a prisoner is sodomized in a precinct bathroom. And when Mr. Lawline claimed the driver, who was Schwartz, held him down, and witnesses put Schwartz going there, I guess it would prove to be too much to overcome, unfortunately.
And if you were representing Justin Volpe, would you have tried to plead him out and try to get the best plea right before trial or before trial or months before?
Listen, again, second guessing is very easy. If I were representing Justin Volpe, instead of worrying about making all these headlines and that end of the world publicity that I was telling you about, what I might have considered doing was getting him evaluated psychologically from day one, and see if there was anything in his mind that could have caused him to snap that would have been a mitigating factor, and possibly pursue plea negotiations with that being a tool. And maybe he doesn't spend the rest of his life in jail, but maybe 10 or 15 years.
Is there anything you could share with us about all these weeks or months on trial that can give us an insight into what it was like being in that courtroom?
It was really, I love trying cases, Alan. I mean, I live to try cases. I was a former prosecutor. I'll try a defective toaster case if I have to. And I really enjoy being before a jury.
You love asking questions.
And I love speaking. But one thing, thanks, Peter. I'll let you get in a minute. The one thing I actually didn't love was being on trial in this case. And it's surprising to me because I love trials. And this was an exciting case, and certainly it was the
tremendous publicity.
there.
I saw you on the evening news.
But it wasn't fun. It was really, there was so much on the line. It was so tense, and I firmly believed in my client's innocence without question. And that's always an uncomfortable feeling when you're going before a jury and the person sitting next to you is innocent, and you're not sure if that jury is going to follow your lead and accept your arguments. It really caused a lot of sleepless nights.
Did you feel the pressure from the community who was in the courtroom?
No, I really didn't. First of all, I tell you, I honestly was able to block out everyone who was sitting behind me. But I didn't feel pressure from the community. I mean, Weiss was never looked upon by anyone, by most in that community as the bad guy.
Peter, I know when you were the Southern District and Assistant U.S. Attorney, you handle many police brutality cases. Can you tell us about that, what you found? Is there one thread that runs in these cases?
I think it's hard to say whether there's one thread. I mean, there's a large police force in New York City, and there are certain police officers that are capable of horrific acts, and I think it's hard to generalize. I do think one theme that comes out of these cases is what people call the blue wall of silence, and they talked about it in the Lorima case is starting to crumble, and that's why I do think as a citizen that it's important for the prosecution to prosecute these officers for obstruction if they have a well-founded belief that that's in fact what happened with regard to the effort to remove Schwartz from the bathroom where the sodomy occurred.
So, in the moment we have left, what would you like to tell the public about the case?
That one police officer ruined a lot of lives. I mean, aside from Abner Lorima and his family and all the people he caused for them to suffer on the Lorima side of the fence, he destroyed at least the lives of Officer Schwartz, Bruder, and Weiss. Bruder and Weiss were certainly acquitted, but their lives will never be the same. A lot of officers quit the force after that, all because of what Justin Volpe did, and it is really horrific.
And this blue wall of silence?
I don't really subscribe to that theory, quite frankly. There were plenty of officers that came forward in this case who testified truthfully or not and gave incriminating statements about other officers.
Peter Vigeland, thank you very much for appearing on Lawline. Joe Tacopina, thank you.
Thank you.
For appearing on Lawline, as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111.